In this video we want to talk about dispute procedures. Conflict within the workplace is very common. It can take many forms, such as conflict between employees, co-workers, employers and other stakeholders. So having conflict within the workforce is quite a common phenomenon. It can be observed in many places of work. There may be disputes and issues between workers, management, between the workers, between different operators, or between different layers of management. It's almost part and parcel of the human condition. When people meet, they can agree to work together, or they may have disputes. There may be power relationships between them, social issues. It could come down even to prejudice and discrimination. There can be all sorts of issues that separate people out, and these, for various reasons, can lead to conflict. It causes disruption to work routines and can have an impact on productivity if conflict results, for example, in industrial action. So just focusing in on the implications of conflict at work, it can have all sorts of consequences on the organization, on the sustainability of the organization, the survival of the organization. If the conflicts are very deep and very problematic, they can have all sorts of bad consequences for the continuance of the organization. So conflict should be dealt with as soon as possible. When it's identified, it should be dealt with at that stage. If it's left unresolved, it can cause major problems down the line. Unresolved conflict can be a source of issues that crop up in all sorts of situations in the future. So it's best to resolve the issue once it's identified right at the start. Now, conflict can arise for various reasons. For example, poor communications, misunderstood communications, misunderstood the intention of a communication. The words selected were wrong, or were inflammatory, or were interpreted wrongly. So it could be poor communications. It could be inadequate working conditions, that employees find themselves working in conditions that they don't like. It could be noisy, it could be the atmosphere could be not so good, or it could be poor working conditions in terms of the tasks that they were required to do, with highly repetitive tasks, which can lead to boredom. And the problem with boredom is people need to alleviate the boredom, and to do it through conflict, through raising issues. There could be health and safety concerns within the organisation as well, and that could be a source of conflict. It could be that the pay rate is not very high within the organisation, and the employees are disgruntled. They're putting in perhaps long hours and not getting a big wage or salary, a big wage generally speaking. They get paid at the end of the week, let's say. They're not getting a lot for their efforts, so they are unhappy. And if they're asked to do anything further than what they're currently doing, it can lead to disputes. There could be harassment and unfair treatment. The management may make bad decisions and harass some workers, may make their lives difficult. That could be done on all sorts of bases. It could be, as I said earlier, it could be down to quite an evil streak of malice towards a particular worker. A manager simply doesn't like the worker. That could be a source of dispute. It could be other workers don't like a particular worker. That could be a source of dispute. It could be based on race or religion, or it could be based on their appearance or their sexuality. It could be based on anything, and that could be very unfair to that individual, but lead to disputes and conflicts and problems. It could be that the management is poorly trained, that simply Management is inexperienced, they're poorly trained, they make bad decisions, they don't understand the significance of what they're saying, they make their instructions very terse and to the point and very authoritative. Perhaps that's not the way to treat people. Perhaps a kinder way of treating them would be to speak more politely and more in a friendlier fashion. It may be more confrontational the way they present themselves. Perhaps they're poorly trained. Now, workplace conflict can be dealt with by ensuring management are sufficiently trained to deal with conflict situations. It's always a problem trying to sort out a conflict, but normally listening to the issues on either sides and trying to find compromise and centre ground is normally quite a good approach. Trying to have a two-way communication system between employees and management, that's important. I think the literature suggests that the more management listen to the employees, the less potential there is for conflict. Also, the more productive the employees will be, the more cooperative, the more engaged, the more motivated. Having a one-way communications channel from management to employees is not conducive to good working practice. Discipline, grievance and dispute procedures should be clearly expressed to employees and stated in the employment contract. So the employees should know the channels that they can go through if they have got a problem. There should be a recognised grievance procedure, a disciplinary procedure, a disputes procedure. It should be understood by all who are working within the organisation that this is the way forward. And that's to take away the potential for wildcat strikes or unauthorised protest or disputes. There is a set procedure. It could be that the conflict is dealt with by approaching a third-party association on unresolved disputes. Sometimes management and workers can't agree, so they're at an impasse. There's no way forward. They're stuck. They can't agree on the particular problem. They can't resolve it. In which case, perhaps an outside agency can be brought in to look at it. And we'll talk about this later in these slides. We'll talk about outside agencies and how they can be involved. But it could be that the problem will have to be looked at by somebody neutral, somebody outside, somebody who's not directly involved, to try and break the deadlock. Now, dispute procedures, well, conflicts can escalate if not properly resolved. In some cases, disputes can lead to litigation and employment tribunals. So it can be very serious. It can go all the way into litigation, into law. Organisations aim to prevent disputes by going to court. They try to prevent disputes going into court because it is very costly and time consuming. It also affects the image of the organisation, so they try to not go to court. They try to prevent disputes going that far. So organisations try to get involved before it gets out of hand, before it goes too far. In order to prevent disputes going to court, organisations offer alternative dispute resolution, ADR. The methods and procedures must be clearly expressed in the employment contract. So before issues can get out of hand and go to court, let's say, before it goes before a court of law, or before it goes before a an employment tribunal, there may be alternative dispute resolution procedures that the company recognise. Now, these include all methods used to resolve disputes and prevent litigation. So they're trying to resolve the issue, uh, trying to resolve the disputes and prevent litigation, prevent the problem getting bigger. If there's a problem between management and the workers and it can't be resolved by face-to-face discussions and they simply cannot agree, then the company can go to alternative dispute resolution techniques. There could be negotiation. There can be a form of negotiation that's set up between the two of them to try and negotiate a way around the problem. Or they could use something called ACAS, and we'll talk about this again in a few moments' time, which means they could use mediation, conciliation and arbitration. And this will be the subject matter of the almost the rest of this talk. We'll deal with ACAS and with their procedures, but for the moment let's just lead up to it. We'll certainly, the rest of this particular talk will be mainly about ACAS, and we'll talk about what it is and what it means. This is in the context of the UK, of course. Other countries will have other institutions. Some will not have institutions. Some will just leave it to management to try and resolve the issues. So it depends. But this is the UK perspective, and this is the route that's followed in the UK. Let's first of all talk about negotiations before we get to ACAS. The first procedure in resolving disputes is negotiation. It should take place between the parties in the dispute. They should be able to sit down and discuss the problem and understand the issues from either side and see if there is a way of resolving the issue. That's the best way forward. It's to come to an agreement and resolve the dispute. It's trying to find an accommodation, find something in between. It's not ideal from both perspectives because they're trying to accommodate each other, but they might find a way of resolving the issue, something that they can work with, something that they can live with, they can agree to. So it may be that negotiations will throw this up. Negotiation meetings could be structured and coordinated, ensuring all participants have the opportunity to express their views. There's no point in having negotiations if only one side talk. Negotiations should involve all the interested parties who should state their point and clear the air. Make it clear to everybody what they want and what they see as the issue. And then for the negotiations to try and resolve all of these issues and see if everyone can agree on a solution to go forward. It's in all of their interest to find a solution. The company needs a solution because it wants to continue in business. The employees want a solution because that's their income. Those are their terms of employment and their working conditions. So it's in everyone's interest to find a solution. It's just trying to find the solution that solves the particular problem. That's the issue. So negotiation process usually involve the following members. The parties at the dispute obviously must be involved. Let's say it's the management on one side and the trade union on the other, or the management on one side and some workers on the other side. So it should involve the people who were involved in the dispute. That's clearly the case. Could be union representatives and middle management, for example. Could be also, if the trade unions are involved, a district union officer and a senior member of management. So sometimes trade unions, if they're involved in the dispute, they could ask for support from a district union officer, somebody not working for the company but working for the union, who will come in from the outside and will give advice to the union on the negotiations. But also perhaps a senior member of management may get involved as well. It could be that regional union officials are involved. It depends on the scale of the problem, the size of the company, the number of workers involved. But it could be trade union pour a lot of effort and a lot of resources into supporting this particular case. But likewise, the management may involve employer associations and seek help outside of the company. You can clearly see here that what could start as perhaps a small problem can become quite big. It could have started as a big problem, and of course to try and resolve it and make sure it doesn't even get bigger, perhaps strikes or company closure, then these various tiers of involvement may be recognized. Now let's talk about this ACAS that I talked about in the context of the UK. This is the Advisory, Conciliation and Arbitration Service. Now, it's a statutory agency. It's a voluntary and independent statutory agency. In other words, it was set up by the government, and it's voluntary. It's not forced on anyone, and it's independent. It's independent from everybody. It's independent from the employers, the trade unions, from one type of management to the next, to different types of workers, different types of occupations and trades, and it's independent. It's just a statutory agency. It's set up by the government and funded by the government, and it offers free advice and support to try and resolve disputes and try to bring about peace within the service and industrial sectors. Now, it's the main provider of ADR, Alternative Dispute Resolution, services in the UK. So ACAS is a major player in ADR, in Alternative Dispute Resolution. Organisations can contact ACAS to help settle disputes. So when there's a dispute and it can't be resolved internally, both parties can't agree, so they're in deadlock, there's no way forward, they just simply cannot agree on a solution, then ACAS may get involved. They may be invited to get involved. Both parties, both management and the unions, or management of the workers, must agree that ACAS be contacted to see if they can help. ACAS offers assistance with the following: conciliation, mediation and arbitration. So it offers three types of facility: conciliation, mediation, arbitration. I want to talk about each of these, what's meant by conciliation, arbitration and mediation. ACAS initially offers conciliation services to settle disputes within the affected between the affected parties, I should say. Conciliation services, it tries to offer these. This is the initial one. This is where it starts. So let's say a dispute is brought to ACAS, brought to the Advisory, Conciliation and Arbitration Service. They will start by trying to find some sort of conciliation. This is when a third party, usually a conciliator sent by ACAS, to help facilitate the dispute resolution process. So some sort of conciliator, some sort of trained negotiator will be sent by ACAS to talk to both sides to a dispute, to try and find some sort of way forward, to see if he or she can understand the problems on each side and see if there's a way forward, to try and conciliate, to come between and bring both parties together. The conciliator's role is to sit with each party, listen to disputes and offer constructive feedback and solution for resolving the disagreement. So the conciliator tries to resolve the issue, tries to understand what's going on, understand the nature of the problem, come up with recommendations and proposals, and tries to bring both sides together. A conciliator does not have the power to make decisions or impose their views on the parties in the disputes. The conciliator just makes recommendations. It's just trying to find a solution, offer a solution to both parties. Somebody on the outside looking at it objectively, trying to make proposals. The conciliator's role is to facilitate, advise and offer solutions. It can't force solutions onto people. It can just recommend. The parties in the dispute take on board the suggestions. However, they decide if and when to settle the dispute. So the parties can take on the recommendations. They can listen to the conciliator and understand what's been said, but they don't have to settle. It's voluntary. There's no force being used here. ACAS only initiates a conciliation process if internal dispute resolution methods have been ineffective. So ACAS will only get involved if every effort was made on the part of, let's say, the union and the management to resolve the issue before ACAS was called in. ACAS doesn't come in straight away. ACAS is not for that. ACAS is only there if a dispute is in existence, and that dispute arises out of negotiations that were conducted within the organisation prior to ACAS's involvement. Now, the conciliation process involves researching the cause of the dispute. The conciliator must understand the cause of the dispute, must arrange meetings with individuals and groups of members involved in the dispute, both sides must talk to the conciliator, both sides must agree to the involvement of the conciliator, so the conciliator will call meetings and talk to each side. The conciliator will encourage communications between both parties, arrange meetings where both parties can discuss their concerns and work together to find a solution. The conciliator may arrange meetings, perhaps meetings which failed in the past, before ACAS was involved, before the conciliator was involved. But organise the meetings again. This time the conciliator may be present and listen to what's been said and make notes and go back and talk to each side and bring them together yet again, this time with a new perspective, perhaps one that only an outsider can bring, somebody not involved in the day-to-day processes of the company. So the conciliator is trying to bring them together. There's negotiations, trying to find compromise to settle the dispute and arrive at a mutual agreement. The conciliator is trying to nudge each side closer together. Slight compromises here and slightly more offered on one side and more agreement on this side, and gradually moving both parties together until finally there's very little between them. There's very little causing the dispute, at which point the conciliator may make some suggestion which will resolve the issue. So the conciliator tries to bring both parties together, perhaps bit by bit, slowly, by listening to issues and trying to resolve one issue after the next and getting agreement, getting negotiations. After conciliation, if the dispute continues, if conciliation fails, ACAS will arrange for mediation. That's the next step up. Mediation is a process where an independent person or board of mediators is appointed to settle the dispute. So sometimes 2 or 3 mediators may appear and try to resolve the dispute. Mediation, independent person, somebody outside the organisation, outside the company, knows there's a problem within the company, there is an issue between management and employees. The mediator will go to try and attempt to resolve this dispute. It may be, as I said, it might be 2 or 3 mediators involved. Depends. The mediator considers cases from both parties, so it asks both parties to make cases, to present what their position is, and the cases must be brought forward in writing for consideration. Sometimes when people have to write down exactly what the dispute is. That can be part of almost the healing process. That can be a part of the resolution, because the written word somehow is different to the spoken word. The spoken word sometimes is more emotional, more vehement about its position. The written word is more dispassionate. It's calm. It's stating the case. It's stating the logic of the case. So the mediator asks both sides to state their cases on paper. The mediator will hear both cases and view all supporting evidence at a hearing. There will be a hearing convened by the mediator, and both cases will be listened to, and they will look for any supporting evidence to support the cases that were made. So it's not a court of law, it's not a legal situation, but it's almost there in terms of its procedures. It's asking both sides to write down their case, and then it has a hearing and it asks them to prove what they've said. Then the mediator will make a formal proposal and recommendations for settling the dispute. The mediator will issue what he or she considers to be the solution to the problem. The recommendation is not legally binding, and the parties have the right to accept or decline the decision. So the mediator states what he or she thinks is the solution, and then the management or the union, let's say, decide whether to accept it or reject it. But that will be the solution. The final service offered by ACAS is arbitration. The process is referred to as binding arbitration. Now, if the mediator's proposals were rejected, and if conciliation had failed, the final stage is arbitration. Now, both parties will have to agree to this. If they agree to it, you can go ahead and ACAS will offer this service. The final decision by the arbitrator is final and must be accepted by the parties, because they've agreed to it. If they agree to arbitration, then they must accept the outcome. All parties involved in the dispute process must agree to arbitration in order to proceed to settlement. So the parties must agree to arbitration. They must agree to this type of settlement. Now, in this case, this is the end process, and this is when the dispute has gone as far as it can in terms of getting compromise between them. This case, an arbitrator has been agreed to, let's say, and the arbitrator's decision will be final. The arbitration process involves the selection of an arbitrator, either from ACAS panel or appointed by ACAS. So somebody who's independent of the unions and of the management, somebody who's outside the industry perhaps. It could be a legal person, a lawyer, a solicitor, a barrister. It could be a retired judge. Depends on the scale of the dispute. Depends on the scale of the industry or company or the importance of the company. So the arbitrator can be someone respected by both sides. Both sides will agree that this person is fair. Arrangements are made for an arbitration hearing. All parties in the dispute have the opportunity to submit all evidence, written statement and arguments. So now the arbitrator calls for everything, calls for the two sides to make their case. A formal hearing is then arranged for both parties to state their case. So both parties submit all the evidence, written accounts, written supporting evidence, and so on. So the arbitrator is in possession of all the information from both sides. Then the arbitrator calls a formal hearing. Both parties are invited to state their case. The arbitrator will then view each case confidentially and arrive at an independent decision. After the hearing, the arbitrator will go away, think about it, think about the evidence, think about what was said, and try to come to an independent decision. Within 2 weeks, the arbitrator will announce the outcome and deliver the award through ACAS. So the case will be awarded to one side or the other, and it'll be done through ACAS because the arbitrator was appointed by ACAS. All parties in the dispute must accept the decision as binding and end the dispute. They agreed to binding arbitration. They must therefore go back, and the one who perhaps lost by the decision of the arbitrator, they must still go back and continue to work. So this is the final stage in dispute resolution, arbitration. So what we've done in this session is looked at different ways of approaching disputes, employee disputes, management disputes within organizations, how the disputes can be resolved through negotiations, through mediation, and finally through arbitration. It's important to be familiar with these terms. They are spoken about quite frequently in the context of employee relations. That's all we're going to deal with here, so let's leave it at that and say thank you for watching.